The courtroom smelled of lemon oil and old paper, like a living room that had been kept polite so it could never breathe. Light fell in a clean, indifferent strip through the high windows and cut across polished wood, catching on the brass nameplate of Judge Lawrence P. Henderson. He sat behind a raised bench with the patience of a man who had seen too many human dramas dressed as logic. Keith Simmons checked his watch with a small, satisfied movement. The gesture was precise, practiced, the same one he used when dismissing people who needed him. His suit sat on him like armor. His smile had the easy curve of someone who believed his own press. Around him, his camp, Garrison Ford at the forefront, murmured as if victory were only a formality, a token they would collect on schedule. Grace sat alone on the defense bench. She wore a simple gray dress, sleeves modestly to the wrist, hair pulled back in a way that made her cheekbones look more delicate. A thin silver bracelet circled her wrist. It was the only thing of jewelry she allowed herself now. Her hands were folded in her lap. There was a small dark mark on the edge of one thumbnail where she'd been cleaning studio brushes all week until morning light crept in and told her it was time to go to court. She had liked the city in an untidy, stubborn way. The way paint dried on a fire escape. The way the subway rattled and carried the same strangers day after day. She had liked how a palette could change mood in a room. She had liked the noise of a room full of people making the same decision. She had not liked this, the way faces watched as if assessing the animal to be culled. She had not liked the dull expectation pressing against her as if the law itself were a commodity Keith could buy. The bailiff, Officer Kowalski, stood with hands clasped in front of him, a neutral sentinel. He was the kind of man who had learned the value of silence. The gallery smelled faintly of perfume and coffee. A woman 2 rows back tapped her phone, sending a short, nervous pulse of light through the room. Somebody had already live-streamed enough of the morning that there would be pixels of this moment stashed on servers with headlines to come. Judge Henderson's gavel rested like a metronome between beats of conduct. His voice, when it came, folded into the room with careful authority. "We will come to order." Garrison rose slowly, leaning toward the microphone so each syllable could be sharp and assured. He had the practiced cadence of a man who had spent years turning other people's misfortunes into memos and motions. "Your Honor, we move for a default judgment. Ms. Simmons does not have counsel on the record, has failed to answer." He let the sentence hang where it would do the most harm. He flicked his eyes at Keith and then returned them to the judge, the movement like a well-oiled signal. The judge steepled his fingers and regarded Grace as if sizing the facts against a ledger. She did not look at him. Her eyes seemed far away, past hems of behavior, into the place that mattered more than any podium. A fault line of memory ran beneath her calm. Signatures she had been asked to sign at midnight, spreadsheets she never understood but trusted someone else to manage, a bank account whose numbers were meant to make art possible, and instead became a quiet ledger of someone else's appetite. "Ms. Simmons," Judge Henderson said, "are you intending to proceed pro se today? Do you have counsel?" It was not a sentence meant to shame, technically. It was a test, procedural, an inquiry into how the machinery of justice should be engaged. The question landed in Grace the way a cold draft might. For some people, an answer would be a point of pride. For her, it was a fissure. She opened her mouth. Nothing came out at first. The silence amplified the room. Too much texture, too many opinions filed like paperwork against her. The whispers folded up behind columns of wood. Keith smiled in the way predators do when a creature freezes. "I thought she'd fold," he said softly, to no one in particular, the words a pinprick of casual cruelty. Garrison, sensing the moment, laid out the mechanics. "Your Honor, default is appropriate when a defendant has been properly served but declines to present a defense. We have complied with notice. We are prepared to prove up damages and make a declaration of Ms. Simmons's, for lack of a softer word, disinclination to participate." It was a lawyerly way of saying, He expected the rest of it to be bureaucracy. He expected a bench ruled favoring his client and an early exit for the cameras. Grace kept her hands folded. Her breath did not shake. From the outside, it looked like surrender. From the inside, it was a small, controlled thing, the way a painter holds a brush before a stroke that will matter. When the judge hesitated, it was less a pause and more a breath. He watched her face with a jurist's curiosity and passed a ruling that would seem fair. I will allow a brief period for Ms. Simmons to indicate whether she intends to retain counsel or proceed pro se. If she cannot, I will hear the motion. The court clerk tapped a stack of papers. Somewhere, a courtroom reporter shifted the tape in her machine. Time had a way of keeping legal moments small enough to be digestible. Keith leaned back, smugness growing into a grin. He believed the rest would unfold like a well-scripted play. For the first time since she sat in that bench, Grace let herself feel the humiliation. It came like a light that exposed small things. The tiny fray in the hem of her dress she'd meant to fix at home, the smell of turpentine caught in her hair, the way people measured poverty and posture. A woman in the gallery looked at her and then looked away, embarrassed at the sight of a private defeat made public. If anyone was watching for an answer from Grace, it would have seemed as if she had none. If anyone was listening for a plea, there were none of those either. She only sat and allowed the room to do its work. And then the door to the courtroom opened. It happened with the kind of dramatic punctuation that a movie director envies. The door swung inward on a precise hinge and a sound spread, not loud but impossible to ignore. The click of high heels across marble, the murmur of air moving around an entrance. Heads turned. Keith's grin flinched. She entered like someone who believed the world could be reshaped by the angle of a shoulder. Catherine Bennett wore white, and the garment seemed carved to say two things at once: authority and refusal to hide. Her hair was silver, cropped close, not the old lady gray of retreat, but a deliberate modern stripe that framed a face both precise and lived in. She carried no bag but a slim leather folio that contained, as would become painfully obvious, a file the size of an old ledger. A hush fell for the space of a fraction of a second, which in courtrooms is an eternity. People rearranged themselves, as if the room was now a stage and new lighting had come in. Catherine's eyes found Grace with the speed of someone who counts the value of human beings the way a banker counts currency: efficient, exact. There was recognition there, but not the soft kind. It was a recognition that said, I know what you've been through, and I know what I have to do. Ms. Bennett, Judge Henderson said with the thin, neutral surprise of a man who reads the docket like a calendar. It was noticed, but not novel, to have a late counsel appear. What drew attention was not merely that Catherine Bennett had entered, but who she represented. For a long time, Grace had believed her mother was the thing she had always missed. Distant, successful, someone who had built a life out of principle and courtroom wins, who loved the law enough to wedge it into her personality the way other people wedge religion. They had not spoken in years. An argument over what it meant to be family. A funeral that had been handled from across a transom. The kind of silences that creep into decades and call themselves decisions. Grace's marriage had been an attempt, in its earliest days, to be something else entirely. A refuge, an ally. Instead, it had become a ledger of small erasures. Now, the person who had taught her to sign her name in a careful, readable script leaned into the room like an incoming tide. Catherine did not rush, but there was a clarity to her motion. She moved to the counsel table, sat like a woman who belonged, and opened the slim folio. Toby, her junior associate, hovered a respectful step behind, carrying a stack of manila binders as if they were sacred texts. There was a murmur in the gallery. Someone named Sasha shifted in her seat and tapped her fingernails against a plastic cup. A man 2 rows over craned forward. Catherine placed the binders on the counsel table with a sound like a small tree falling. The labels on their spines were printed in a clinical font. Forensic audit, bank records, text messages, crypto transfers. The words read like a plot outline in a genre Keith had not wanted anyone to read. Garrison's jaw moved. He had known of Catherine Bennett, the woman who threw cases like storms, the kind of litigator whose name made opposing counsel check their shoes for cracks. He had not expected her in a white suit, not in his courtroom, not representing the very person he had assumed would never find a champion. "Ms. Bennett," he said, standing, voice clipped. "This is hardly timely. We object to this ambush." Catherine's eyes did not flicker with indignation. Instead, she smiled, small and precise, the way someone who knew exactly how to open a safe might smile before turning the handle. "Your Honor, I don't represent myself as anything but timely in presenting facts. Ms. Simmons is Ms. Grace Simmons, the wife and the central figure in this action. I appear on her behalf." Her voice was low enough that for a heartbeat, a court reporter's pen had to catch up. Then Catherine did the thing that made the room lean forward. She motioned to Toby, and the junior associate handed a single copy of an appearance to the clerk. "The court needs to be apprised immediately," Catherine continued, "that there are pressing issues here beyond the mechanics of, or the niceties of, a default motion. There are emergent assets at risk, active concealment, and evidence that would be materially prejudiced by a default at this stage. I request a short recess, so the court can receive an emergency filing and for counsel to examine the accompanying documents." Garrison barked an objection that was half procedural habit and half displeasure. "Your Honor, setting aside theatrics, Ms. Bennett's filing was not on the docket. We have notice obligations. She is asking for a recess to present evidence," Judge Henderson interjected, not unkindly. "What is the nature of the emergency?" Catherine folded her hands in the way a principal folds a lesson. "Your Honor, in short, there is compelling evidence that Mr. Simmons has transferred significant marital assets through a chain of corporate entities into accounts not listed on any marital disclosure. Some of those funds were then converted to crypto. The transfers appear to have occurred in the months after Ms. Simmons was removed from active control of the financial accounts, and there is reason to believe they were concealed through forged documents." The word forged landed like something thrown into water. Ripples went out. Keith's hand tightened around the arm of his chair. A bead of sweat formed at his temple and did not yet fall. The court asked its usual skeptical follow-up. "Are you in a position to lay that before me now?" Catherine reached into the binder closest to her and drew out a single printed page, crisp white, a financial trail the size of a line item. She did not flourish it. She pushed it forward, and the clerk took it with a professional flatness. The page contained a wire transfer record. There were bank names, letters spelled out that to many in the room would mean little more than a pattern. There were dates and amounts. And in the middle of the columns, a number stood stark and obscene, $20,000. Catherine did not shout. She let the number speak. "An initial transfer on February 14th, 2022. The amount, Your Honor, is $2,020,000, transferred from an account listed under Sovereign Holdings LLC to a chain of shell companies with ties to a cryptocurrency exchange. We have bank authentication, internal emails, and a forensic blockchain snapshot that shows the assets at one point moving into a wallet with ties to Mr. Simmons's business associates." The courtroom breathed in collective disbelief. Keith's face tightened the way a fist tightens on a rope. Garrison's objections had drained from him, replaced by a glossy calm that was trying to look like control. He muttered about chain of custody and authenticity and all the niceties that are the air the legal predatory breathe. Somewhere in the back, a woman whispered the figure as if it were a rumor. Grace felt the number as if it pressed against her sternum. 2 million. It did not resolve what had gone wrong in the marriage, did not fix the nights of being told small, cruel things, but it was a thing, concrete and sharp. For the first time in months, something in the room had been named with a clarity that could be held. "Mr. Simmons," Judge Henderson said, "do you wish to address?" Before anyone could answer, a small man in a gray suit moved from a bench and stood near the counsel table. He was one of Catherine's junior associates, possibly the person who had been waiting in the hallway with a stack of binders. His name was announced politely, Toby, yet his presence mattered only insofar as he carried with him a quiet. She had brought experts, there was a chain of custody, and there were people who had sat with spreadsheets and followed money the way detectives follow footprints. Garrison's objection swelled again. Your Honor, even if this transfer exists, it does not resolve the procedural issue before the court. Appearance at this juncture is not a magic key to reopen procedural default. Catherine smiled at him with the steady patience of someone who had been underestimated her whole life. No, Mr. Ford. It's not a magic key. It's a matter of fundamental fairness. If assets are fleeing the jurisdiction, if they are being diverted to concealment, to avoid satisfying a judgment, that's not procedural theater. That is a substantive injury. She held his gaze for a second, that felt like the hinge point of an entire short play. And I have the documents to show it. The judge tapped a small file he had been holding. I will allow a brief recess to allow opposing counsel to review the proffered documents. Ms. Simmons, if you wish to retain Ms. Bennett as counsel, you will have an opportunity to make that clear. Given the representation and the nature of these allegations, I will also direct a temporary hold on any immediate dispositive orders until counsel has had time to inspect the materials. However, the court will not. He did not promise the world. He was not granting a freeze, not yet. He was a judge, and there are proper steps to doing such things. But in the space of that sentence, the hard assumption that the day was a given for Keith had been disrupted. The script had shuffled. Grief and relief are not mutually exclusive. They can sit together like strangers at a bench. Grace felt both. Her fingers brushed the silver bracelet. She had not wanted, or perhaps had not dared, to trust her mother. The estrangement had been a wound, and Catherine's life had been a fortress. Now that fortress walked through the door with binders. As the clerk shuffled papers and men in suits murmured, the press tilted their cameras, hunting for a frame. Catherine refocused, pulling a pen from her lapel and crossing a checkbox on a cover sheet with a crisp stroke. She spoke softly, but with the clarity of someone who believes law is a language meant to cut to truth. Your Honor, with permission, I would like to present Ms. Elena Morales to the court. Ms. Morales is a certified forensic accountant who has examined bank ledgers, corporate filings, and transaction logs. Her preliminary analysis reveals patterns consistent with intentional concealment, misnamed payees, backdated transfers, and the use of shell entities that point to an effort to obscure the ultimate beneficiary. Elena Morales, tall, earnest, wearing glasses that slid down her nose, rose to approach. She was not the kind of person you would describe as theatrical. She smelled faintly of coffee and the kind of concentrated work that left behind the faint aroma of printer toner. She carried with her a thin binder that was technical and deadly in its own way. Garrison tried to corner on the authenticity of the materials. How did you obtain these documents? Are they originals? Are they authenticated by the institutions that held them? Ms. Morales spoke in clear syllables, the voice of someone who had spent years teaching evidence to people who preferred instinct to invoices. The bank statements are copies of official SWIFT receipts and were obtained through formal requests to the financial institutions involved. The corporate filings were pulled from public registries and verified with a private investigator who performed due diligence on offshore entities. The crypto snapshot is a blockchain audit prepared by a chain analysis firm that provided a time-stamped hash to corroborate the transfers. A few listeners, those who thought they understood cryptocurrency at least, nodded in half-new ways. Others simply registered the language as professional. Your Honor, Ms. Morales continued, the pattern is not decorative. It suggests a deliberate conversion of marital funds, and the amount is non-trivial. $2 million. The figure still hung in the room like a banner. Garrison's backhanded calm stiffened. If these documents are admissible, Ms. Bennett will have to lay foundation, subpoena, and comply with discovery schedules. The court cannot accept a rush based on an opening page number. Catherine's expression suggested she expected as much. She folded her hands and met the judge's eyes. "We will comply with the orderly process, Your Honor, but we ask for a narrow protection, a temporary restraint on transfers from the accounts identified, pending confirmation. We will provide the court with the authentication and affidavits within 48 hours. The word temporary restraint was a legal phrase with practical teeth. It did not lock the door closed forever, but it did put a block on movement. It was procedural, precise, a way to prevent the thing that Catherine alleged: the dissipation of assets while the court considered whether they were marital and whether they were being concealed. Judge Henderson considered, tapping a pen. He was a judge not given to theatrical pronouncements, but he was not blind to the need for balance. "Counsel for the plaintiff?" Garrison told the judge what a reasonable man in his posture might say: that such a request required more than a single page, that due process demanded notice and opportunity, that a restraint on assets could itself be abused if not carefully administered. He insisted on the forms, on the process. He insisted, as good advocates do, that the machinery grind in the applicant's favor. And yet the nature of the courtroom is such that once someone asks for a safety measure with the correct procedural language and can point with sober fingers at a ledger, the judge finds himself at a crossroads between caution and deluge. He could let the day's script run and hand Keith a small ceremonial triumph, or he could take the safer route and, for the moment at least, stop the mobile assets from migrating beyond the court's reach. "The court will take a recess of 15 minutes to allow opposing counsel to examine the proffered documents and confer with their client," Judge Henderson ruled finally. "If, after that period, sufficient basis appears to justify a temporary restraining order, counsel may present a short form for the court's consideration." It was not a victory. It was not an exoneration. It was a doorway ajar. Grace took a breath she hadn't realized she'd been holding. She felt the tremor start at the edges of her hands, that small internal tremor that comes before tears. She kept her face steady. She did not stand. Not yet. The world in the room rearranged itself around the new fact that the man who had been smiling might not be able to spend what he had hidden. Outside the courtroom, in the hallway that smelled of institutional coffee and the faint ozone of fluorescent lights, there had been a life before this hearing. Paintings hung in a cramped studio with imperfect lighting, canvases leaning against each other like soldiers, nights worked through because the work was hunger and habit. Grace had kept records of her own in ledger notebooks with little tabs: materials, sales, gallery contacts. She had believed once that if she worked hard enough, art could be her answer. It had been messy, fragile, and, against all expectations, enough to keep her afloat. Her mother had not been there at the opening of any show. They had spoken once that last year, over a strained dinner, words grinding into each other like stones pressed together until nothing remained but dust. Catherine had left that night with the implacable expression of a woman used to choosing law over kin. Grace had learned to fold her life around the absence. Now she watched her mother consult with Toby, exchanging notes in shorthand that was sharp and private. Catherine's jaw set the way a person's jaw sets before they carry out a careful plan. Toby whispered a figure. Catherine nodded. They moved like a unit that had rehearsed the choreography of disruption. Keith bristled in the corridor. He took a long, performing breath at the side of the bench and turned to Garrison. The two of them had worn confident faces long enough that it was a shock to see vulnerability threaten to arrive, like a weather system changing overnight. "We make a show of it," Keith said. "We'll offer the judge a settlement. We'll say it's all been a misunderstanding." Garrison made a sound that blended amusement with thin calculation. "Negotiation is always an option, but theatrics blow both directions, Mr. Simmons. If there's a chance your transfers look anything like concealment, you could be looking at an ugly discovery." They spoke with the small conspiratorial economy of people who believed words could be used to shape outcomes. Nobody in the hallway considered that equally staged was a woman who had been abandoned, and a mother who had, for reasons of her own, kept some cards close. When the recess drew everyone out and the doors opened, whispers spun through the corridors like loose thread. Reporters formed a shadow line near the bench with presses and recorders, and the small appetite of the modern spectacle. The forensics of money had become a new kind of theater, and Catherine Bennett had just stepped onto a stage where currency and reputation could be dissected. In the privacy of their conference, Catherine's voice was cool. "We need to be surgical," she told Grace in the small space between lawyer and mother. "We will not be theatrical. We will be precise." Grace's throat tightened. This was the woman who taught her to read a contract, who had once made a child sit for hours decoding terms like consideration and clause. She had been the kind of mother who judged with a law book and then, when needed, left the child the rest of the world. There was anger in Grace, no small thing. And there was relief too, complicated and pearled. "Why now?" Grace asked quietly. She did not mean why the entrance had aligned with a courtroom calendar. She meant the larger why. Why it had taken this long for a parent to step back into the worn territory of pain. Catherine's face softened for a fraction. She could not fix the hollow years. She could, however, move now. "Because you are my daughter," she said simply, as if that were argument enough. "Because the law is the one thing I can offer that is both honest and brutal. Because I counted the ledger and the math did not add up." They were not in the gallery now. They were two people standing at a doorway. Behind them, the city moved as it always had. Taxis and delivery bikes and a news van already positioning itself around the courthouse corner. When they returned, the courtroom felt small again. The judge's expression had assumed the neatness of someone who accepts the procedural as the appropriate cure for public spectacle. Garrison, for his part, had prepared an objecting speech that relied on a certain expectation, that late evidence is bad evidence. He had a ready flurry of rules in his back pocket to throw at any attempt to clamp down on his client. Catherine anticipated him. She had an air of readiness that comes from being used to a battle that begins long before anyone realizes the field is set. She handed the judge a concise affidavit from Ms. Morales and 3 copies of the binders. She did not raise her voice. She did what one does with evidence. She let it sit, heavy and mapped on the table. "Your Honor," she said, "we ask not for a ruling on the merits at this hearing, but for a narrow order preventing further dissipation of assets pending review. We will provide a sworn certification of the chain of transfers, affidavits from the banks, and the forensic report." The judge read the materials as if they were the first book he'd opened that day. He nudged his glasses. He read. He asked measured questions about how the banks had authenticated the records, whether subpoenas had been issued, whether the evidence had been collected in accordance with rules that would make it admissible later. Catherine answered in the language of process. Subpoenas had been issued. Ms. Morales had been retained and had prepared a report summarizing the transaction history. Third-party audits had been requested. When she mentioned the word crypto in the dry language of chain analysis and wallet addresses, there was a stir. The technology had been, until recently, a fog on which clever people had written fortunes and footnotes. Garrison moved to object, and he did it with the air of someone disciplining a minor transgression. He pressed about notice, about the plaintiff's right to respond, about the dangers of restraining without full vetting. He asked with attorneyly calm if the court would be prepared to take such temporary custody of a judgment before the due process that would affirm any claim. Judge Henderson, who had the temperament of a man who spends his days balancing scales, placed the case in the smaller box. He would not make a grand pronouncement. He would, as per habit, give each side what it could reasonably ask without upsetting the machine. To prevent irreparable harm pending a fuller hearing, the judge said slowly, the court will enter a narrow order prohibiting transfers from the bank accounts identified in the submission, and will allow counsel 48 hours to provide the affidavits and materials. This is without prejudice to any party, and is a temporary step to preserve the status quo. It was a measured, careful thing. It did not convict. It did not exonerate. It did not lock away the money forever. It did, though, prevent a discreet erasing of assets while the court considered allegations. For Grace, from the hollow of no legal counsel to a mother at her side and a judge who would at least pause the movement, the day had become something else. In the tiny pause that followed the judge's order, a small, soft sound came from Grace. A breath so small it could be measured in the lift of shoulders. The bench was not victory, but it was not nothing. Catherine's hand found Grace's at the edge of the table, the contact brief and not performative. It was a recognition of kinship and strategy. The cameras captured a moment that could be cut and replayed in 24-hour cycles as a headline: "Estranged mother steps in." The reporters found their angle with the mechanical appetite of the trade. But in the narrow focus under the oak-paneled roof, there was a more private shift. Grace had been alone under the law's gaze. She now had someone who could translate the ledger's language and fight it. When court recessed again to handle the practicalities, filing the formal motion for a temporary restraining order, serving subpoenas, lining up expert affidavits, the energy in the hallway was a charged thing. Keith's face had drained to a pale version of its former smugness. He clung to a public face like a life raft, but his hand trembled when he dialed his phone. Catherine did not speak loudly about William, Grace's father and Catherine's ex-husband, though she had the look of a woman who had long ago made peace with the knowledge that family money complicates everything. William might move later. Some mortgage claim or trust amendment could rear up and complicate the order. Catherine's eyes flicked once toward the side of the hallway where the press vans clustered. She understood the choreography. Legal fights were often followed by public narratives that tried to turn nuance into moral clarity. "Keep the studio inventory list close," Catherine told Grace in a low voice as they stepped into the small conference room. "All original receipts, any images of bank statements you have, even personal notes. Don't delete anything. Emails, texts. If you have any documents Keith asked you to sign, bring them." Grace nodded. She did not have to pretend she understood all of it. She had canvas, charcoal, plywood. She had a binder of early sales and a handwritten ledger with gallery contacts scrawled in pencil. She also had a set of emails from a decade ago in which Keith discussed investments with an ease that had always made her slightly uneasy. She had not burned them. Catherine's counsel was not theatrical, it was methodical. The first part of the storm, for now, had passed. The court had not yet dismantled Keith's life. It had not yet exposed every deceit. It had, however, allowed a mother to step into a child's battlefield and put a hand on the map. People observed. People took notes. A friend from a gallery texted a single word: "Finally." When the doors of the courthouse opened and Grace stepped into the sunlight, the city felt larger. She had a year of uncertainty ahead. She had an opponent whose resources were massive and resolute. She also had the evidence of staggering sums moved with a quietness that would, unless something miraculous happened, not vanish without trace. Catherine moved through the crowd with the easy gait of someone who knew how to win. She had, after all, built a career on turning numbers into narratives and narratives into rulings. She believed in the law's slow arithmetic and its ability, sometimes, to set right what private cruelty had tried to make invisible. They had not won. They were not yet vindicated. But the door had opened, and someone powerful had come in. Inside the courthouse, in the residual quiet that follows judicial movement, Garrison put his hand flat on the table and looked at Keith. "We need damage control," he said. Keith inhaled, a sound that might have been a laugh if it had been unfettered by nerves. "Make it go away." Garrison's smile was tight. "We don't make things go away, Mr. Simmons. We argue, we delay, we negotiate." Catherine, returning to her table, opened the binder and with a steady thumb slid out a chart. It was a line tracing transfers, routing numbers, the kind of thing that took time to read, but once you saw it, it made a kind of ugly sense. At the bottom of the chart, someone had highlighted the phrase, ultimate beneficiary. The sun outside the courthouse door reflected off a news van's chrome and made a bright and literal flare. The city continued. A cab horn argued with a bicycle messenger. A man skateboarded past a mural of an artist who had painted her last show on a whim and sold 3 pieces the next week. In the courtroom, the papers were not yet fully examined. In the binder, the numbers had weight. The scene had changed. She had been alone in a room. She was no longer the only one in it. If courtroom comebacks get you fired up, tap like, because what came next would make a lot of people rethink what it means to underestimate someone. The recess had been short, but it did what courts are meant to do. It gave the machinery time to align. When the doors reopened, the chamber had a different gravity. Reporters straightened. Spectators inhaled. Keith's earlier ease had been replaced by a carefully arranged mask, the kind men like him wore when they needed to look resolute on paper and imploding in private. Catherine rose and, with an unhurried motion, produced another layer of the case. The binders had been a first salvo. Now she brought in witnesses already waiting, men and women who lived by following money. The courtroom, which had smelled of lemon oil and old paper earlier, now carried the colder aromas of electronics and dry erase markers. A different kind of work was being aired. Elena Morales remains available to lay her report on the record, Catherine said. I also call Mr. Daniel Reed from Chain Trust Analytics to attest to the integrity of the time-stamped blockchain snapshots. Daniel Reed stepped forward, a compact man with wire-rimmed glasses and a soft voice that became hypnotic when he started to draw lines. He approached the lectern with a tablet in his hand and a stack of printouts. He smelled faintly of hand sanitizer and the paper ink that bankers use to make things seem inevitable. State your name for the record, the clerk said. Daniel Reed, Chain Trust Analytics, he answered. I am a forensic analyst specializing in blockchain transaction tracing and reconciliation with traditional banking records. Catherine had him explain simply how a hash is a unique fingerprint, how a snapshot can be time-stamped by a reputable third party, and how, while blockchain addresses are pseudonymous, patterns of movement and connections to known entities can be traced with reasonable assurance. She did not dive into arcane detail. She translated for the room, the way a woman who had taught others to read contracts makes legal text feel like readable language. Elena returned to the stand, her binder open to charts that looked like the underside of a map, nodes, arrows, a river of money. She walked the court through the cleaned-up ledger, transfers from sovereign holdings to shell companies, subsequent wires to an exchange account. A crypto purchase that, within days, was moved into a wallet whose cluster analysis linked it to people within Keith's business network. This isn't speculation, Elena said. It's a pattern, an intentional routing of funds in a way consistent with concealment. The amounts, the timing, the use of entities with nominee directors all suggest an effort to hide the trail. A juror, there was no jury yet, but if there had been, would have seen the map and understood the truth as something mechanical and cruel. Money can move like a river, and some hands make sure it disappears beneath the surface. Garrison's objections came like a cough in a quiet room. Your Honor, we object to this foundation being laid piecemeal before discovery obligations are fully met. Chain analysis is still an emerging field. It's admissible as expert testimony, Catherine interrupted, calm as someone commenting on the weather. We will provide the reports and the proper affidavits in the time ordered by the court. For now, I offer the testimony to establish a prima facie basis for the court to consider provisional relief. Judge Henderson listened, pen tapped, a man weighing language and precedent. He had neither the appetite for grandstanding nor the inclination to let assets slip away because of process alone. He admired process the way watchmakers admire gears. Each one matters. Ms. Bennett's representations are noted, he said. We will proceed with the testimony and obtain the written affidavits in the time specified. That small, careful consent from the bench tightened the net. Catherine moved with the efficiency of a surgeon. She had anticipated the skeptical questions, the need to make complex things feel simple and irrefutable. She had also anticipated people like Garrison, whose first weapon is delay. Her next move was a legal maneuver with the cultural impact of a loud bell. She requested the court to take judicial notice of certain corporate filings and to permit a limited subpoena to the cryptocurrency exchange for account records tied to the wallet addresses in question. The courtroom, for a heartbeat, felt as if it had been translated into an accounting office where pennies carried moral weight. When the judge granted the narrowly tailored subpoena, you could see the air shift. It was not that a final fate had been decided. It was that the machinery had teeth now. An outside company would be required to produce records. For the first time, Keith could not simply claim the trail evaporated into some digital fog. Institutions would be called upon to show their books. Catherine's questions to Daniel and Elena were practiced but not theatrical. She was blitzing the room with clarity. Here is the ledger. Here are the connections. Here is the timing. She put up screen displays. Clean, annotated visuals that translated the chaos of spreadsheets into a simple story. Her voice fell to a cadence that made it obvious. Someone had tried to move $2 million and then pretend it had never had anything to do with Ms. Simmons. And can you say with reasonable certainty, Catherine asked, that the transfers were not payments for ordinary business expenses? Elena tapped a highlighted section. The beneficiaries are opaque. We found intercompany invoices that, upon inspection, lacked underlying contracts. The so-called payments link to shell entities registered in jurisdictions that often serve as nominee addresses. Based on industry standards, these are red flags for concealment, not ordinary bookkeeping. The gallery stirred as if bitten by some collective dawning. People like simple narratives, good versus bad, liar versus honest. So Elena's charts performed an important cultural work. They made complexity look like culpability. Keith's jaw worked. He had a technique to his discomfort, a way of pretending the discomfort was a small thing. But under Catherine's questioning, the small things in his accounts looked like a pattern. He shuffled papers, whispered to Garrison, tried to find a note he had prepared for the theater of cross-examination. Catherine's strategy, however, was not to make him stumble on technicalities, but to force him into a moment where his own language would betray him. She had one clear objective. If he was to testify, she wanted him on the stand where the record would be clear and where his words could be held. Your Honor, with permission, I will call Mr. Keith Simmons as a hostile witness, Catherine announced. There was a soft intake of breath. Calling the opponent as a hostile witness is a theatrical device in courtrooms. It allows a party to treat the witness as adverse. It also invites exposure because the witness is compelled to answer and can be pinned to statements under oath. Keith stiffened. He had expected a predictable script, a default ruling and a neat exit, but the legal script had been overturned and replaced with a public cross-examination. You may, Judge Henderson said, after a look that measured risk and fairness. Keith took the stand. The room rearranged its attention. He was the same man who had been fashionable and assured in his tailored suit, but sitting in the witness chair, he looked smaller, an image that will become familiar to anyone who has watched people accustomed to control get put to the test. The clerk swore him in. His hand hovered above the Bible because lawyers still like pageantry more than is strictly necessary. Catherine began with the basics: name, address, occupation. Her questions were soft at first, simple, factual. Mr. Simmons, do you recognize Exhibit A? A printed wire transfer pulled from the stacks. He did. He squinted as if the paper were undecipherably technical. He answered, implicating the familiar truth that people often think numbers are invisible until someone reads them aloud. She layered the questions like a painter building color: date, amount, recipient, routing. Each small admission produced the sound of a trap closing. Rustle of pages, someone in the gallery shifting forward, the whisper of a camera focusing. Then Catherine brought up a name. Who is the beneficial owner of Sovereign Holdings LLC, Mr. Simmons? He fumbled. Then, with a practiced evasiveness, I believe it's the company established for various investments, Catherine was precise. Who directs it? Who signs for it? Keith's eyes darted. He tried the old chestnut. Corporate separation. I'm not directly involved in day-to-day operations. Who authorized the transfer on February 14, 2022 to the cryptocurrency exchange? Catherine pressed. He swallowed. The disguise of vagueness slipped. I authorized it, he said too quickly. The word landed like a stone. A murmur ran through the gallery like someone moving a curtain aside. Garrison's face registered first a flash of concern and then the pale beginning of panic. There are moments in court when a lawyer flips from advocacy to triage. Garrison was moving into triage now. Did you disclose that transfer on your financial statements in the marital disclosures? Catherine asked. There was a pause. The question was designed to let the record expose its own failure. Keith swallowed again. No, he said. It wasn't listed. You did not, she summarized. List the transfers, the accounts, or the account's beneficiaries in the disclosures provided to Ms. Simmons and to this court. No. The words hung, pure and precise. The gallery felt the gravity of an omission made public. In family law, financial disclosures matter. Failing to disclose assets is not merely poor bookkeeping, it is the scaffolding for claims of concealment. Catherine moved then to the forged documents. Signatures that purported to be Ms. Simmons's consent to transfer rights. Corporate minutes that showed board approval without corresponding meeting minutes. She had a handwriting analyst on standby to explain signatures' inconsistencies. She did not have to use him yet because the basic facts were aligning. Transfers had occurred, they were substantial, and they had not been disclosed. Mr. Simmons, she asked, did you instruct anyone to draft corporate minutes that would retroactively authorize transfers? Keith's composure cracked in a way tiny and human. A bead of sweat eased down his temple. Yes. I suggested drafts. Did you sign Ms. Simmons's name on any documents? Catherine asked. The courtroom seemed to tighten like a fist. Keith's reply was a negotiation. I signed documents that I believed authorized transfers. I didn't... His voice faltered. You signed her name? The judge asked, leaning forward. Keith's gaze dropped. There were signatures. There were countersigns. It's a little more accountable to say it plainly, Catherine said. Did you sign her name? Sometimes, he admitted. The word was small, brittle. There it was, an admission that would later be read over and over in press summaries. In the moment, it was a fact that sat heavy in the public air. A husband had signed a wife's name to documents transferring substantial funds without disclosure. Garrison rose, face white, voice unsteady. Your Honor, I formally move to strike that testimony. It is self-serving and... The motion was a desperate attempt to stop a leak forming a flood. Judges do not often strike properly elicited testimony on simple motion. The judge, who had been careful and attentive, maintained his composure. Mr. Ford, he said, you will have your opportunity to cross-examine or move in the appropriate procedural posture. For now, this court is noting the testimony. Garrison's jaw quivered. He had always prided himself on controlling the narrative for his clients, arranging their schedules, arranging their statements, keeping the lights in the rooms where they might seem secure. Now his client's mouth had done what lawyers hope only in movies. It had betrayed him. The cross-examination was not yet over. Catherine had one more careful question, the kind that shows moral clarity as a legal point. Did you ever put funds into an account in your own name as a personal reserve? Funds that you did not report to the court? The hesitation was long. In that long half-breath, you could see the map of years. The small humiliations Grace had lived through. The times her voice had been discounted. The nights she had balanced rent on tight teeth. Yes, he said finally. I converted part of it into crypto and moved it. It was... He struggled for a justification that would pass as motive. It was for business. The court will note your testimony. Judge Henderson said. "I will permit the record to stand." It was a spectacular unraveling. Not because the witness had gone theatrical, but because he had given the court access to the truth in a methodical way. Catherine had not relied on melodrama. She had relied on records and the stubbornness of facts. When Keith left the stand, his face was an artful mask of damage control. The cameras flashed. Phones in the gallery translated his words into live captions. Social media would turn the sound bites into memes. For Grace, who had been sitting on the defense bench, the sound of his admissions felt like 50 small curtains being drawn back, revealing a longer, uglier stage. Garrison, seeing the record, made a misstep that would be remembered by those who watch the legal profession for its dramas. He moved to withdraw as counsel. "Your Honor," he said, standing too quickly, "I do not believe I can adequately represent Mr. Simmons under these circumstances. I move to withdraw." It was a move born of panic. Lawyers sometimes withdraw when they feel a client has acted with untruthfulness or when a representation becomes untenable. The court has discretion to allow or deny withdrawal. In the middle of a hearing, especially one with immediate provisional relief on the line, judges are often unwilling to grant a sudden exit because it can prejudice the opposite party. "You may file a motion to withdraw," Judge Henderson replied coolly. "This is not the time for counsel to vacate the field mid-hearing. You will remain as counsel of record for the present proceedings unless and until the court grants leave." The courtroom murmured. The procedural device had a real-world bite. Garrison could not simply step away and leave Keith scrambling. He had to continue at least until the court decided his request. His face suggested he might prefer to disappear. "Your representation is noted," the judge added, "and you may file the motion, but I decline to permit an immediate withdrawal without a hearing on that motion." It was an admonition and a practical holding. The judge was protecting the process, not favoring either side. But for Keith and for Garrison, the message was plain. The day had turned into an adjudicable contest, and the lawyers in the room would have to see it through. After the testimony and the motions and the careful back and forth, the judge turned to the immediate question: provisional relief. Catherine had asked for a temporary freeze on the accounts, and for an order granting Grace occupancy of the marital residence pending further hearings. Both requests were framed as measures to prevent irreparable harm. "How does the plaintiff respond?" Judge Henderson asked. Garrison's protest sounded thin now, procedural string against the weight of the documents. "Your Honor, a freeze could inflict hardship on my client if the court misapplies its discretion. We ask for narrowness." "Narrowness will be the order," the judge said. "But I will also note that the court will not permit deliberate dissipation while credible allegations of concealment exist." He signed a short-form order, a temporary freeze on the identified accounts, prohibition on transfers, an order that the plaintiff could not liquidate works or sell certain named assets without court permission, and an interim grant of occupancy to Ms. Simmons for the penthouse pending a full hearing. He also indicated he would refer the matter to the district attorney's office for potential criminal evaluation regarding the possible falsification of documents and alleged concealment of assets. Those were referrals judges use when evidence suggests criminality. They do not condemn, but they put the matter in an entirely different procedural lane. When the gavel tapped, the sound was metallic and final for the small pieces of paper on a bench. For Grace, it was the tentative first plank of a bridge. Outside, however, another scene was ready to complicate the moment. Courts often come with postscript dramas, people who make last-ditch claims in hallways or parking lots where press vans and irate relatives collide. William Simmons, Grace's father and Catherine's ex-husband, had always been a man who showed his money the way some people show their names in neon. He had watched proceedings from the perimeter with the sort of restrained interest that suggested he was waiting for a pivot he could use. He intercepted them in the courthouse parking lot where the air reeked of exhaust and the sun felt thin against the buildings. William's mouth had a particular curve, less arrogance now but a steadier, practiced menace. He was used to turning documents into directives. He had once run a lending enterprise that viewed life's complications as structured loans. "You think you can freeze a man's assets and his home on a smile?" William said, his voice carrying the abrasive texture of someone who had never learned to be gentle. Catherine regarded him without theatrics. "I think the court will do as the court believes just," she said. "And if you have a claim on the mortgage or an assignment of rights, then file it in the appropriate forum." William produced a folder with the slickness of a man who carries paperwork like a card sharp. He slapped it on a hood and opened it as if he wanted it to read like a sermon. The document inside was a trust amendment. Last minute, tidy, an amendment that purported to grant him an equitable right to the penthouse if certain loan defaults occurred. He had a notarial stamp and what looked like a convincing signature. "It's ironclad," he said. "This loan defaulted last season. The amendment is valid. I have title documents. You freeze accounts, fine. But the house? You'll find I have Catherine's hand went to her phone and called a clerk. She asked for copies of the trust files and flagged the amendment for immediate forensic review. There is a legal choreography for this sort of claim. Notarizations can be checked, amendment dates verified, signatures compared. Catherine had, years before, built a practice on being suspicious of convenience documents that appeared just when they were needed. "You'll need more than a folder to take a home from a woman named on the deed," she said. She placed a calmness over the parking lot like clean linen. "We'll examine your amendment. If you've been honest, we will respect it in court. If you haven't—" William's face tightened. "You cannot bully me with procedure." "This is not bullying," Catherine replied. "This is the law." Back in the courthouse, she had already arranged for a handwriting expert to compare signatures. She had ordered a notary search to see if the notarization was properly recorded. The notary's records came back quickly. The notary number did not match the stamp. The purported date on the amendment was later than the notarization, and the signature bore a slightly different slant under magnification. Catherine walked William through the analysis with a legalist's patience and a daughter's sharpness. "This signature," she said, pointing to the magnified image, "differs in pressure and the crossing of the T's. The notary's journal shows no record for that date. The amendment purports to be executed when your loan was allegedly in default, but the bank records show no such notice was issued until months later." William's mouth opened and closed like a man who had been struck by a small practical truth. He had expected that cash and a notarized page could turn a fight into an outcome. He had not expected Catherine to bring a team that thought notarizations could be cross-checked and signatures analyzed. The confrontation reached a kind of tidy humiliation. William's loan claim crumpled when Catherine presented a line of evidence showing the amendment was likely forged: a post-dated signature, a notary inconsistency, and an absence of the necessary trustee's consent. Faced with the facts and the threat of a perjury referral if he proceeded with a knowingly false claim, William retreated with something like dignity's last scrap. Catherine did not relish it. She did not gloat. She simply pointed out the obvious. If you make a claim and fabrications support it, you invite legal consequences. William knew the calculus. He folded his documents and left, the click of his heels echoing the sound of retreat. That parking lot episode mattered because it cleared a route for Catherine to secure Grace's home, not only by the judge's temporary occupancy order, but by removing the specter of a competing claim. It was a collateral victory, one of those small bureaucratic triumphs that make larger justice possible. The weeks that followed were an exhaustion of procedure and the slow, focused work of forensics. Catherine worked with Elena and Daniel to file proper affidavits. Subpoenas were served. The exchange produced an account statement that confirmed transfers. The corporate veil was pulled back a degree when a reluctant corporate secretary, spooked by the subpoena, produced minutes and emails that revealed Keith's fingerprints. The district attorney's office took an interest. Their referral was not a verdict, but the mechanical beginning of criminal review. Indictments are not instantaneous. They are official gestures that ask a prosecutor to weigh evidence and decide whether to bring formal charges. As the legal machines turned, A different kind of life unfurled for Grace. The freeze on certain accounts prevented Keith from liquidating the assets he had covertly redirected. That meant, after negotiations and judicial rulings, that some of those assets could ultimately be subject to division in family proceedings and could be used in liquidated forms to satisfy judgments. The court ordered a forensic accounting to determine the extent and nature of the transfers. That accounting produced a recommended judgment amount greater than simple repayment. Damages for concealment and punitive awards were proposed. Garrison's career took cornered turns. He tried to spin the record, to argue that his client had only behaved as men in his client's position often do, imperfectly, but not criminally. But public admissions under oath, signed documents revealed as forgeries, and corroborative corporate emails made spin thin. Clients in the legal world watch how other clients fare. Garrison found new work harder to come by after the headlines. Keith's public persona unraveled in slow, relentless increments. The bank accounts were frozen, the crypto wallet was traced to a series of transfers that had been converted into stablecoins and then into fiat in an offshore account, and the chain tracing revealed intermediary actors who, under subpoena, produced emails showing Keith's involvement. The district attorney convened a grand jury. Indictments eventually followed on charges related to falsifying documents and financial fraud. Those charges do not come lightly or quickly, but once a prosecutor decides to pursue them, the machinery moves. All of that, however, is epilogue in the immediate sense. At the time, Catherine's victory was narrower. She had stopped the leak. She had gotten the court to notice that money had moved. She had put a bandage on the wound while the infection was examined. It was enough to keep Grace in the apartment and to prevent the immediate disappearance of funds. Grace's days turned into a new shape. Where once the most immediate acts of her life were measured in studio time, in a patience that required pigment and light, she now spent hours poring over ledgers with Catherine's team. She learned the language of audits just enough to hold a conversation. It annoyed her in a way that felt like reclaiming an old muscle. Catherine, who had been convinced the law was the proper tool for remedy, would not let Grace loose of the details. Knowledge was, in her view, a kind of protection. "You need to know how they hid things," Catherine told her. "You are part of this. You do not get to be a witness to your own life." That sentence became a motif in Grace's slow return. Don't be a witness to your own life, be its author. The media followed the seismic beats, the admission on the stand, the freeze, the referral to prosecutors, but they could not capture the quieter work. The late-night meetings with Elena to cross-check bank timestamps, the patience of a clerk stamping documents at 3 p.m, the junior associate Toby making sure every subpoena box was checked, and then, as the grand jury investigated and the civil process continued, something else happened that had nothing to do with courts and everything to do with the sun. Grace returned, slowly, to the studio. She painted in bursts, short flurries of creation that felt like the first tentative footsteps after a long illness. She worked in charcoal and then in paint, making canvases that felt to her like statements rather than pleas. She stopped hiding small details in the corner of rooms. She started signing her name in a bolder hand. Several months after the high day in the courtroom, the district attorney announced formal charges. The press released headlines that made simple narratives of complicated processes, and the internet furnished commentary that felt like commentary has always felt. But the indictment was a formal recognition by the criminal process that probable cause existed for prosecution. It meant a trial would follow, or at least the defendant would have to answer the charges in a public legal arena. Eventually, after plea negotiations and careful work by the prosecutor's office, which had amassed their own exhibits and witness list, Keith pleaded guilty to charges including falsifying documents and financial misrepresentation. He was sentenced to a term that took into account his cooperation, the civil settlements he had negotiated, and the punitive damages ordered in the family court. Those legal outcomes did not erase the months of humiliation Grace had endured. They did, however, reconfigure the ledger. The forced liquidation of certain assets and the restitution awarded in the civil case provided Grace with financial security. It did not make her wealthy in the tabloid sense. It made her solvent and safe, enough to rent a studio space unfettered by threats, to pay her debts, and to set aside a modest fund for future shows. The epilogue of courtrooms is often the epilogue of life: press, cautious interviews, and a slow turning back toward normality. Grace used the newfound space to stage a show, the kind of show that would have marked the end of one life and the start of another. She called it rebirth, for lack of a better word, because it fit and because she liked the bluntness of a single-syllable title. The gallery was small and intimate: steel beams, white walls, perfect track lighting. Friends and strangers crowded in. Critics took notes with an economy that suggested they understood the significance. Catherine came. She did not stand on the podium or make speeches. She simply moved through the crowd, nodding at admirers and ignoring the small cameras that flashed. When she reached Grace, no one noticed the way her face softened for a fraction. "You did the work," she said, meaning the art and the legal patience both. Grace's paintings sold that night, some to private collectors, some to a community fund Catherine insisted be set up. The press wrote the story like a tidy moral: woman wronged, returns to art, vindicated. It glossed the complexity, as press often does. But the people in the room, other artists, a few lawyers, a patron who had collected one of Grace's early pieces, felt the truth. The work had given Grace a voice, and the law had given her room to use it. She used some of the proceeds to form a small foundation, Grace's Reclamation Fund, to support artists who had been financially victimized or exploited. It was modest and sensible. It funded short-term grants, legal clinics, and counseling. Catherine donated time from her firm as pro bono advice. The fund's first grant was a small one to a painter who had been stiffed by a gallery. The public liked the neatness of it. Of course, consequences are not only monetary. Keith's reputation crumbled. Clients who once courted him filed suits for his mismanagement elsewhere. Garrison's association with the case cost him referrals. The legal community watched and quietly reallocated their trust. William retreated from public life, his loan business suffering the reputational damage that follows exposure. Catherine kept her practice and accepted a few feature pieces in legal magazines about forensic accounting's role in family law. She did not boast. She scaled back interviews and returned, to her surprising pleasure, to quieter cases. Grace, meanwhile, discovered that the quietest part of reclaiming a life was not negotiation with lawyers or victories in courtrooms, but the long and slow task of trusting herself. She unpicked the years where someone else had balanced her budget and, in small ways, took on the accounting of her life. An appointment here, a contract there, a decision to sell a piece instead of letting someone else take it. The rebirth was not a sudden sunrise, but the steady return of light through many small windows. On an ordinary Tuesday, months after the trial, Grace and Catherine walked along the river. The air was early fall, crisp and non-fictional. They spoke about nothing momentous: upcoming shows, a lecture Catherine might give at a law school, the names of painters they each admired. There was a politeness between them that had been built on harder things: mutual respect, shared pain, and a recognition that the law could mend some things but never all. "You did something I couldn't in time," Catherine said, with that particular mutation of regret that looks like apology without the word. Grace stopped and looked at her. "You did what you could," she said. "You came when the door opened." Catherine's eyes narrowed into a small smile. "I came because I could." Grace's reply was quiet and folded. "People confuse silence for weakness. I learned that my silence was a kind of reservoir." Catherine laughed softly. "Reservoirs need control valves." They walked on in silence for a while, the city doing its ordinary commerce. The world had not been entirely corrected. There were still creditors, and there were still reputations to rebuild. But there was a stability in the ordinariness that felt like enough. In the months that followed, the headlines softened and the art reviews sharpened. People stopped talking as much about the courthouse and more about the canvases. Grace's rebirth show traveled to a small regional museum. The fund she established helped a handful of artists stay afloat. Grace sat for a radio interview, answering questions about what had changed. She spoke carefully about the law, about the role of family, and about the way art had been both a refuge and a fight. When the interviewer asked her what it felt like to stand in court and have a stranger's handwriting read as evidence against those who tried to take her life, she answered simply, "It was a strange moment when truth turned up like a stubborn thing. Silence can be mistaken for surrender, but sometimes it's strategy. Sometimes it's the way you hold yourself until you know where to land your voice. I don't think weakness and silence are the same." Catherine watched from the side of the room as Grace walked through the gallery, surrounded by friends. She had been stern and procedural, and sometimes distant, but she had, in an unglamorous way, moved her life to make room for a daughter she had not known how to reach until needed. On a rainy evening after the gallery had closed and the last guests had gone, Grace stood alone by a painting that captured a sunrise over an industrial skyline. A piece that had not sold that night, but which she loved. She thought back to the day she had sat alone on the defense bench. The smell of turpentine clinging to her hair, the shame thick as a curtain. The memory no longer throbbing but settled into a story she could tell herself without flinching. She ran a hand along the dry paint. The canvas was warm with the work of hands and the residue of days. She felt gratitude, not the loud, tidy gratitude that fits press releases, but the slow kind, a patient tether. When she left the gallery, Catherine met her at the door. They walked to their cars together, not as a grand reconciliation, but as people who had learned to operate within a new covenant, one of accountability and a willingness to help when the law could be a shield. The moral of what had happened, compressed by those who like tidy endings, was this. She had been alone in court, small and quiet, when the law threatened to treat her silence as absence. She would have been done if the game had run on schedule. But someone entered the room, the one who had the language and the force to make the ledger speak. And the room changed. The door had been the pivot, not because entrances are magical, but because sometimes the right ally arrives with the tools to translate hidden things into visible truth. Catherine was not vengeance personified. She was a lawyer who performed the law's work with precision and a mother who finally chose to be present. The victory, such as it was, belonged to procedure and to persistence. The rebirth that followed belonged to craft, painting, paperwork, patience, and the determination not to let the story be written by someone who had lied. Grace's life did not end with a single courtroom cheer. There were years of work, of small appointments, of trustees and accountants and gallery schedules. There were still days when the old habits of quiet threatened to return. But she had, in the end, what she had wanted most: a sovereign space to make art and a seat at the table to decide what to do with the proceeds. She had learned to speak in a way that was not always loud but was present and exact. And for those who stood in the courtroom that day, those who had expected a perfunctory victory for Keith Simmons, the lesson was small and elegant. Do not mistake silence for weakness. Underestimation is a kind of hubris. It invites a counterforce. When Catherine walked through that door, the room did more than change. It recognized that law, properly exercised, can be a companion to art and a remedy to deception. Months later, press accounts would condense the story into tidy lines. Estranged mother and powerhouse lawyer saves artist wife from financial ruin. The headlines were not wrong. They were simplified. The real truth was messier, human, and entirely earned. A quiet woman reclaimed her life because someone with the means and the will entered and translated the ledger. In the end, Grace sold the painting of the sunrise to a collector who promised to lend it to a public institution when funds allowed. She used part of the sale to secure the next year's studio rent and another part to seed the reclamation fund. She and Catherine attended a small dinner one evening, toasting to the modest victories, repaired reputations, legal reforms suggested at the Bar Association, a foundation helping artists. They did not make a spectacle of it. They understood that the true satisfaction, the vindication that felt right, was not the ruin of a man, but the restoration of a life. The city kept its rhythms. Taxis honked, neon flickered. In a quiet gallery across town, under the glow of tracks and white paint, people paused before a canvas that had been born in the rubble of loss and legal battle, and breathed in its colors. They talked about technique and the human story that informed the work. They left feeling something small and domestic had been made public. A woman had found her voice and used it. Grace walked home that night with a lightness that was both foreign and familiar. She thought of the day she had sat, alone, in a room that smelled of lemon oil and old paper. She thought of the sound of the door when Catherine had entered. Neither moment was miraculous in any supernatural sense. Both were simply human acts, one of endurance, the other of decisive intervention. She looked up at her building where, months earlier, the possibility of eviction had been a threat. Now it stood as a shelter and a studio. She unlocked the door and, in the quiet of the small apartment, she hung a painting on the wall and, for the first time in a long while, signed her name with steady ink. If you know someone who loves a comeback, share this story. And if you want to hear more courtroom turnarounds and stories of quiet people becoming loud enough to be heard, subscribe for more.